News. Weekday afternoons from 4 until 6 on The Shaw, 540 AM and 101.1 FM, WAUK. Weekday afternoons from 4 until 6.
Welcome. Grab your favorite morning beverage and join us for Morning Canollis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning. It is Saturday, February 3rd, 2024. And yes, my name is Jim Santel. I am going to be your host this hour and next hour as well on our Saturday morning broadcast. I am delighted. I am excited to have you with me this morning. We've got a lot of things to cover this morning, as we always do on our Saturday morning broadcast. I'm delighted not only to have you as a part of our listening audience, but also to have me in the studio with my good colleague and friend, Johnny, who's going to be supporting and assisting me today as my producer. As always, this is our morning review, our analysis, our discussion of some of the most significant and impactful news events, developments in the areas of law and government and the aspiration for justice in America. And again, I invite your involvement in our discussion this morning. Johnny and I will be taking your phone calls at that number. It's 844-967-2789. One more time, that's 844-967-2789. Or as Johnny and Anya always remind me, you can also go online, civic media stations, find your particular broadcast station, find the folder for our Saturday morning broadcast, and write to us electronically. We'll be able to take those notes and comments as well. As always this morning, as we get into our ambitious but achievable syllabus, we've got three principal questions. They include, what happened? What happened in the past week? What happened the past days? What happened the past month or so? What do we know? What are the facts of things that are out there? Why are those things important? Why are they significant or material or relevant to the world in which we live? And what, if anything, should we be doing about those things, our actions, our responses, our answers to some of those principal questions about what happened and why are they important? Today, as always, a syllabus that includes an awful lot of things in the area of civics and government and law and the aspiration of justice in America, including as we start out, some analysis of something that a candidate for the presidency of the United States of America wrote late night, one of the nights of this past week, in connection with our judicial system. We're going to take a look at that, parse through that through a rule of law, justice, and court-related lens, try to figure out what exactly is credible, what is not credible in the statement placed on social media this past week about a recent piece of litigation in the civil courts of America. We're going to talk about that, analyze that as a way of getting us all into the subject matter of civics this morning. Beyond that, then, we're going to talk about what just happened yesterday, which is the certain postponement of this major trial being brought by the Department of Justice and the special counsel, his name Jack Smith, pending right now before a district court judge, Tanya Chutkan. She announced a major decision last night about the scheduling of that. Not at all surprising, given what's happened. We'll talk about the reasons for that, what she said, what she didn't say at the time of her decision about scheduling, and how that's going to impact not only that particular trial, but what's going to be coming up in 2024 generally as we go into and continue to be into our election year. Then beyond that, we're going to spend a lot of time this morning, as we often do, focusing upon the United States Supreme Court more and more as we recognize the United States Supreme Court in our contemporary times, taking on issues that historically in our nation have been the purview of our legislature, our executive branch. Now, more and more, we've got courts, including our United States Supreme Court, deciding many issues that have a direct and important impact upon our lives. We're going to talk about some of those cases, including, yes, indeed, the upcoming campaign and whether or not one of those same candidates who's writing on social media just this past week, whether he can appear on a ballot, on a Republican primary ballot in the state of Colorado. You know what that's all about. We're going to talk about what's going to be happening next week. So bring out your calendars, bring out your pens so you can mark next Thursday, February 8th, for an important event happening before the United States Supreme Court in that important case called Trump versus Anderson. The entire month of February is going to be a big month for oral arguments, cases pending before the Supreme Court. We're going to talk about what the docket looks like right now, and then talk about two other sets of cases that are also going to be the focus of the Supreme Court's attention in the month of February 2024. We're going to talk about two major cases having to do with the internet and social media, the interaction between all of that and government, and what you can expect in terms of decision-making coming out of those cases. It's going to have a tremendous impact upon how we understand the relationship between government and postings on social media, the internet generally. We'll talk about those two cases as we have done before. They're coming up for oral argument as well. And then we're going to finally talk about a case at the end of this month, likewise coming up, having to do with guns in America. We have chatted a lot on this broadcast about this whole series of cases pending in front of the United States Supreme Court affecting Second Amendment issues, gun issues, firearms issues in America. This one having to do with bump stocks. Oral argument about the legitimacy, the capacity of the federal government to restrict bump stocks as we go forward. We're going to chat about that this morning as well. Then we're going to talk about something that happened in the past. You will recall well, that in June, late June of last year, the United States Supreme Court in this major case found for the first time in decades that it is impermissible, constitutionally impermissible for colleges, both private and public, to address issues of race when it comes to deciding who is going to be in their incoming classes. Major case of last term in June of last year, and having implications, as we predicted then, on what's going on today in our universities, both public and private, throughout the United States of America. I'm going to give you some sense of some anecdotal support for the results of that major decision. We're going to talk about what it is that students are doing today and how it is that even guidance counselors and teachers are recommending that students put together their applications in the wake of that major case involving Harvard and also involving UNC, but actually involving all colleges and universities in our land. Many months after that decision, what is the impact? What's going on today in February of 2024 impacted so dramatically by what the Supreme Court decided way back in the summer of last year? Then we're also going to spend some time talking about immigration. This notion that James Madison, George Mason, others established would be the exclusive purview of the federal government in our Constitution. We're going to talk about the war, if you will, with a small w, the battle, the legal battle, and the procedural, a practical battle right now going on between the executive branch and the Biden administration, the Biden White House, and Governor Greg Abbott in Texas. It is manifesting itself in two very significant ways. We're going to talk about something that happened just about 2 weeks ago, again, coming out of the Supreme Court. And then we're also going to chat in that connection with the Department of Justice also discussing in the courts what it is that the state of Texas can and cannot do when it comes to the enforcement of immigration policies and practices. The Department of Justice taking on the state of Texas and some legislation passed by its legislature, signed by its governor, that intrudes upon the exclusive purview of the federal government to oversee immigration issues in this land. We're going to talk about that and what the United States Department of Justice, through Merrick Garland and other offices there, is doing to address those immigration matters involving not only law enforcement, but also, yes, something as practical as barbed wire along our southwest border. Then we're going to chat in our second hour and probably beyond into the next broadcast next Saturday as well, about a number of things happening in our courts beyond those major issues pending before the Supreme Court that affect our Constitution. We're going to talk about a recent sentencing of an individual, formerly of the executive branch, sentenced to some time in prison for his failure to abide by a congressional subpoena. We're going to talk about a major sentencing of just this past week of a defendant formerly employed by the CIA, the Central Intelligence Agency, compromising our national security, our nation's secrets. We're going to talk about the circumstances that brought him into federal court and the consequences of his actions, resulting in a 40-year penalty sentence imposed upon him. And then, finally, in connection with things going on in America, changes in the ways in which we think about the impact not only of civil but also criminal prosecution. We're going to talk about this case in Michigan. This case involving the parents of a young man who engaged in a mass shooting. We'll talk to you about, once again, the circumstances of that and the decision by a prosecutor there in the state of Michigan to sue, to criminally charge the parents for involvement in and support of those actions, those horrific, catastrophic actions by their son. We're going to chat about the pendency of that case and what's going to be happening probably in this coming week. This coming week, again, not only important for the Supreme Court cases, but also a lot of things going on in courts around America. Highly likely, although we're not going to spend a lot of time talking about it this morning, that sometime next week, the sitting judge overseeing this major case involving valuations by Donald Trump. This case brought by the Attorney General of the state of New York, Letitia James, against Donald Trump, his sons, and the organization. This case that took weeks to try, now pending before Judge Arthur Engoron, and the likelihood that sometime soon, maybe even this coming week, he is going to issue his written opinion deciding how much Donald Trump and the affiliated defendants are obliged to pay to the state of New York. Anticipate that order perhaps coming out as soon as this coming week, certainly very soon. The judge there has committed to the parties. He's going to get his order out sometime. He said initially in late January, in early February. That is this time. And so next week could be a hugely important time, not only for decisions, but also things going on in the courts of America. And so let's begin. Let's begin our focus this morning on civics. And as I said, a little bit different start today. We recall from our previous discussions, you know well from your own digesting news reporting and other kinds of media out there, that E. Jean Carroll, in a series of lawsuits, civil lawsuits in the federal district court, was successful in bringing a case alleging defamation against the former president. Some of that involved in statements he made even while he was the president of the United States of America, resulting recently in an $83 million judgment against him. When we come back after this break, I'm going to talk with you about Donald Trump's posted reaction to that. We're going to analyze that, pull that apart, figure out what he says that's legitimate, if anything, what he says is illegitimate about the way that courts work, about civics in America, and our understanding of the administration of justice. Stay with us for that continuing discussion here on our Saturday morning broadcast, the studios and the broadcast stations of Civic Media.
Are you telling me the things you're gonna do for me? Yeah, I ain't blind and I don't like what I think I see.
And we are back in our Saturday morning broadcast. Thank you once again for joining me on this Saturday morning, February 3rd, 2024. I am your host this hour and next hour. My name is Jim Santel. As promised, we're going to begin our substantive discussion this morning by taking a look at a civics statement, some civics propositions offered by a gentleman, a man who is right now running for the presidency of the United States of America, who also found himself recently on the receiving end of a very significant, a huge monetary judgment, a case brought by E. Jean Carroll, her attorneys, finding that in the end, Donald Trump not only defamed her, a finding made in a previous trial, but also now that he is obliged to pay her $83.3 million, that including a package of both compensatory damages and punitive damages altogether, the lion's share of that punitive or punishment portions of that judgment. That judgment entered just recently. In the wake of that, obviously, statements by all the parties about the legitimacy and the illegitimacy, at least if you're Donald Trump, about that jury verdict. And in fact, just this past week, Donald Trump, on his own social media outlet, said this. We're going to read through the entire posting first. We're going to spend some time getting some understanding about what he says, most of which reflects a complete misunderstanding about civics in America, about how courts work, about what judges do, about what juries do, about what evidence is all about, what pretrial motions are all about. All of that reflecting on Donald Trump's understanding of what goes on in courts, and in particular, of course, a message sent not to the people who understand what courts are all about, but to those people who might be beguiled into believing that what he is saying is true. This is what he wrote at 11:08 in the evening on January 30th of 2024. He said this, again, coming in the wake of this unfavorable decision entered against him by a trial jury in the Manhattan federal court. He said this, he said, "I am in the process, along with my team, of interviewing various law firms to represent me in," and again, the focus on that, representing me in an appeal, capital A, "of one of the most ridiculous and unfair witch hunts our country has ever seen." Witch hunts, all of that capitalized, our country also capitalized. He says the defamation sham presided over by a Clinton-appointed, highly partisan, Trump-hating judge, Lewis Kaplan, who was, together with certain other radical left Democrat judges, one of the most partisan and out-of-control activists that I have ever appeared before. All this coming from Donald Trump at 11:08 on January 30th of 2024. Describes the judge, Lewis Kaplan, as a bully who demanded 2 trials rather than 1, denied me due process, would not allow me to put forth vital evidence, in parentheses, of which there was much, and only allowed me to be on the witness stand for minutes, telling my lawyer what to ask and telling me to only give one-word answers as his wife, that is presumably the wife of the judge, Lewis Kaplan, and friends sat in cordoned-off front row seats watching with glee. Then begins to summarize this overlong tirade about justice in America by saying, "This entire hoax," all capital letters, "is a disgrace to our American system of justice." And it says this, "Any lawyer who takes a Trump case is either crazy," capitalized and also in quotes, "or a Trump American patriot," all of that capitalized. "I will make my decisions soon." Now, why am I articulating that for you? We don't normally spend a lot of time focusing on these kinds of rants in America, but it struck me as I read this, not at 11:09 on January 30th, but afterwards. It's a perfect a way of understanding how it is that courts in America work and how it is that they do not, reflecting along the way the failure of this particular individual, a litigant in this civil case, and also someone who's running to be the president of the United States of America, reflects his basic misunderstanding of how things work. Let's go back and work through all of the things that he says. Now, he does indeed have an absolute right to appeal that decision. He will take that up. If he does, in fact, identify the firm, as he said, who wants to do that on his behalf, he can also represent himself if he wanted to in America. That's a good thing about our courts, both in federal and state courts. If you want to, you can represent yourself. Probably not a good idea given the intricacies and the complexities of appellate proceedings in the federal circuit courts in the Second Circuit. And that's the circuit out there in New York to which he would appeal this decision entered by a jury, by the judge, based upon that jury verdict, goes to the Second Circuit Court of Appeals, interviewing now law firms who may do that. And again, he's got that right to do that. That's probably one of the few things in this entire post that he gets right. And then goes on to say that this is an unfair witch hunt, one of the major, most ridiculous unfair witch hunts that our country has ever seen. Let's talk about that witch hunt aspect. Let's talk about where this case came from. Well, lawyers, whenever they present cases like this in the civil system, unlike the criminal system, in the civil system, have this absolute obligation to put forth in a civil complaint the basis for their complaint, their charges, their allegations against an identified defendant. Now, criminal prosecutors also have that obligation, of course, but for the most part, they are relied, at least in the federal system, on grand juries that review those kinds of things. Here you've got a civil litigant, E. Jean Carroll, through her attorneys, who put together this civil claim. They have an ethical obligation, all attorneys do, to put things in a complaint upon which they believe the evidence will show, provide a basis for it by a preponderance of the evidence. Not to say that all those things come true, but if indeed you put together a complaint, make allegations against any person that are completely unfounded, as we have seen recently, lawyers will get in trouble for that. They will lose their license. They will be suspended. They will be prohibited from trying cases in the future. And indeed, that's one of the reasons why this is not a witch hunt. This is the premise for a complaint. Donald Trump had the obligation and did indeed respond to that. And the witch hunt that Donald Trump describes here was followed with a trial, as we know now, that resulted in this $83.3 million judgment. The defamation sham, he said, presided over by a Clinton-appointed, highly partisan, Trump-hating judge, Lewis Kaplan. Now, that's true. There is a federal judge named Lewis Kaplan. Plainly, he would reject, as I would, this notion that somehow his partisan background, the fact that he was appointed by a president named Bill Clinton, had an impact upon the litigation, his oversight of the jury review of this case. Nonetheless, allegations of bias by this particular litigant against Lewis Kaplan, and then goes on to note that there were certain other radical left Democrat judges. Not entirely clear what that means. Of course, there's only one judge presiding over this case. His name is Lewis Kaplan, and he is responsible, of course, for determining the course of conduct. It all goes back to this fundamental notion about the process. After that complaint is filed, after an answer is submitted, the judge, through his systems of court administration, then responsible for overseeing things like pretrial motions and the conduct of discovery. If parties have disputes about the production of evidence and witnesses, those kinds of things, they can go to the judge, and again, not in the context of a witch hunt, but the judge then reviews those things, takes information, takes argument, takes evidence from both sides, in resolving all of those kinds of situations coming up before him in this case. That's what Lewis Kaplan did, not reflecting the kind of highly partisan, Trump-hating perspective that Donald Trump describes in this post. When we come back, I'm going to go through the second portion of this post and again describe along the way why it is that Donald Trump gets this so wrong, and also by virtue of his misstatements, making us clear on how things do in fact work and did in fact work in this case recently in the federal court in New York. Stay with us for that discussion. Saturday morning broadcast. Thank you once again for joining me this Saturday morning, February 3rd, 2024. We're beginning our discussion this morning by analyzing something that the former president, Donald Trump, president candidate for the White House once again, wrote just this past week in connection with his huge disappointment and understatement by any measure as a result of the $83.3 million judgment entered against him in the defamation lawsuit brought by E. Jean Carroll. Going through this not only to understand why Donald Trump is so wrong on many of these things, but also exposing along the way some exposition about how things actually work in courts. And right before the break, talking about this notion that somehow this was a witch hunt. In fact, nothing of the sort. This is the process by which civil litigants, as I indicated before, bring cases into the federal and state courts of our land, file complaints, file answers, engage not in witch hunts, but attempts to discover the truth, which ultimately results in what? A jury trial, which is exactly what happened here. Along the way, Donald Trump on the 30th of January, 11:08 at night, writes as well that the presiding judge, Lewis Kaplan, describes him as highly partisan, plainly the product, as he says, of the person who appointed him, Bill Clinton, many, many years ago, says he's out of control. He's an activist, one of the most out-of-control activists that I've ever appeared before. And again, what is the role of a federal district court judge? It's not to litigate the case. Instead, it is to supervise and monitor all those things that Donald Trump now complains about, and here they are. He says the judge was a bully who demanded 2 trials. Let's talk about that for just a moment. No, in many cases in which there's a question of liability, there's also a question of damages. And pursuant to that fundamental understanding about the way that many, not all, but many cases proceed in our federal and state courts, the judge divided this case. Bifurcated is the word that lawyers love to use, and the judges also invoke. Bifurcated, broke this case into 2 different portions, and in particular said along the way that one of the things that he wanted to do was to ensure that there was an addressing of liability first, and then secondarily, along the way, if indeed liability was found, that then, under appropriate circumstances, the jury would then go back and take a look at damages. This notion of bifurcation, not demanded by the judge, but an appropriate invocation of the process by which cases are tried in our state and federal courts. It is a matter of efficiency. It's a matter of productivity. It's a matter of focus to ensure that a jury has the relevant evidence in front of it. And if indeed there's not a finding of liability, here there plainly was, but if there isn't a finding of liability, you don't have to get to damages, right? And so that's the reason why his statement about demanding two trials, that coming from the judge purportedly, no demand was made. That's a part of the regular procedure. And then denying Donald Trump due process. The next thing he says, well, let's once again talk about that. Due process. What does that basically mean? It means notice. It means being told the kinds of things that the opposing side is telling you. An opportunity plainly to be heard in court, to confront witnesses, to confront those who might make allegations against you. All of that supremely upheld during the course of this months-long, actually years-long proceeding to ensure what? That in the end, justice is done. The entire jury process is an opportunity for both sides, litigants on both sides, to have people in a jury review the evidence that they are presenting in court. That's the ultimate due process. After, again, notice of the charges, an opportunity to be heard. Fundamentally, that also due process. And indeed, Donald Trump, through his lawyers and directly, given this amazing opportunity throughout this trial to do just that, not denied by this judge, but rather afforded by him, a part of the due process, a part of this trial, and a part of any other trial going forward in America. Would not allow me, he says, to put forth vital evidence, of which there is much. Let's talk about that for just a moment or so. Again, plaintiff has an obligation, the burden of proof here, the preponderance of the evidence is the standard by which E. Jean Carroll had to establish, number one, liability, that indeed this sexual assault did in fact take place in the mid-1990s in this department store in Manhattan. And then also a burden of proof, a burden by a preponderance about the amount of damages that E. Jean Carroll presented. She did that by virtue of witnesses, her own testimony, the testimony of other economists who talked about the damages that she suffered as a result of the defamation that was perpetrated by the defendant, Donald Trump. And then, indeed, he had the opportunity to present that evidence that he wanted to do. He made the selection through his attorney to testify, which he has, again, the right to do. And did, in fact, the judge limit appropriately the scope, the breadth of that testimony? Absolutely. Why? Because this case is all about damages. It is not a retrial of the underlying liability issue. That was found previously, the previous trial by another jury. And so again, this judge, like any other judge, is going to limit by virtue of this focus on relevance, things that are material, things that are significant for the jury to understand. That's exactly what he did, and said to Donald Trump and his attorneys that when you take the stand, you need to talk about things that are relevant to what? To the damages issue. In the end, he did not do that. And the judge did indeed cut him off with respect to one of his answers when he felt he was going down the road that he is specifically prohibited to pursue. And that, again, is what judges do based upon the evidence code, based upon the status of the case, here focusing upon money damages. Donald Trump did not talk about money damages. He didn't talk about his own finances, his capacity to pay a particular amount of a judgment. He could have done that, should have done that. The judge permitted him some latitude. And in the end, his trial attorney decided to ask him just a handful of questions. Some of them focused, some of them not so focused, but that was the due process that Donald Trump, through his attorneys and directly on the stand, was given. What other evidence is out there? If Donald Trump had that evidence, had the obligation on his own behalf, as he said, on behalf of his behalf, and on behalf of his family and his corporation, to present that evidence. He says there are a huge amount of evidence out there. We don't know what that is. Only allowed me on the stand, witness stand, for a few minutes, telling my lawyer what to ask and telling me to only give one-word answers. Again, all of that a part of the judge's appropriate attempt with Donald Trump on the stand to make certain that the jury is hearing things that are relevant, that are not incendiary, that could not cause a mistrial, for example, not limiting the courtroom procedure in a way that would affect the due process being given to Donald Trump. In fact, just affording him precisely the opposite. And this particular judge, as we've talked about before, has given Donald Trump a huge amount of opportunity in this case to be heard and to be heard in the courtroom in front of this jury. Finally, this focus upon this case being a hoax, a disgrace to our American system of justice. Undeniably, this did not go well for Donald Trump. And he's got this huge judgment against him, not unusual for litigants, civil and criminal, who are on the receiving end of judgments with which they do not agree. Plainly, Donald Trump does not agree with this. He's going to take this up on appeal, presumably, if he gets that law firm, if he hires that law firm to do this on his behalf. But the reality is that this is not a hoax, because in the end, the single most important thing that undermines and discredits virtually everything that Donald Trump said about this bad civics lesson he was giving to America, meant to encourage people who do not understand the process, who would be beguiled by his statement. The ultimate thing to understand is this was a jury. The judge did not decide this. The lawyers did not decide this. The witnesses did not decide this. E. Jean Carroll did not decide this. A jury. And where did a jury come from? There are people who are produced from the area, from the community, in this case from New York, brought in to hear the evidence and make a decision, to deliberate, and to come to a decision based upon the standard of proof. This is preponderance of evidence, basically 51%. That's what the judge instructed him to do. That's the due process afforded Donald Trump in this case, as he would be in any other case, and indeed will be by those other trial judges in the civil and criminal setting, which we have yet to hear from. Again, using Donald Trump's own words to underscore the lack of any understanding about the judicial process in America, but also to underscore the fact that indeed this process took years in the making, years of process, giving Donald Trump the due process that he deserves, that any litigant deserves, just the opposite of what Donald Trump wrote to us, wrote to America at the 11th hour of January 30th of 2024. Now, I mentioned already that there are other trials out there coming up. We know that there are at least 4 other criminal cases that are already in the docket. And let's talk about one of those that also was in the news just last night. One of those cases is pending in the federal district court in the District of Columbia. The E. Jean Carroll matter pending in the federal district court in Manhattan. That's the Southern District of New York. This case, this major case involving election interference. Singular defendant, Donald Trump, 4 counts against him, all premised upon the January 6th events and things leading up to that. Brought by the Department of Justice, brought by special counsel. The presiding judge, Tanya Chutkan, in connection with the due process in that case, this criminal case pending in the federal trial court in the District of Columbia, entertained an argument by Donald Trump as a part of the process by which she, like every other judge, like Judge Kaplan, her colleague in Manhattan, also entertained motions. And what did she do? She afforded Donald Trump the opportunity to attack the legitimacy of that prosecution. And in particular, through the motion filed by Donald Trump's attorney, she entertained this notion that a sitting president is immune from prosecution, has executive presidential immunity for all the things that he, perhaps one day she, does while in office. And she resolved that based upon oral argument, on written argument, and produced an opus, if you will, about the notion that our presidents are not kings, as she said, and determined through this very learned statement that she provided to the litigants, Donald Trump, and to the Department of Justice, rejecting this notion that there is presidential immunity in any setting, including the one pending in front of her. Now, Donald Trump, again, pursuant to the due process afforded him in these trials, took this up to the D.C. Court of Appeals. And yes, indeed, the D.C. Court of Appeals has been reviewing Judge Chutkan's order for a whopping 25 days, coming up on almost 4 weeks now. It is getting a bit late. It's getting a bit late. The United States Court of Appeals for the District of Columbia needs to resolve this matter, number one, because it's not a difficult issue to resolve, but second, because as we have talked before and we'll talk again this morning, it has an impact upon the timing of the case in front of Judge Chutkan. She had previously scheduled this case to begin in early March. Just yesterday, Judge Chutkan, based upon the fact that this matter is still pending before the D.C. Court of Appeals, entered a major order. She basically said that she is scrapping the March 4th trial date, and she said that she would set a new trial date for the proceeding in her court in Washington. These are her words, if and when Mr. Trump's immunity claims are resolved. Interesting that she says if, and adds onto that the notion of when. So expressing perhaps through a little bit of her own frustration that the appellate court is likewise not working with all deliberate speed to resolve this. We know as well that those immunity claims were in front of this 3-judge panel of the D.C. Court of Appeals. They heard oral argument on January 9th. That's where we get the 25 days since that time. We talked a lot about what may happen this coming week. It is hoped, certainly, that sometime very soon, before a full month goes by, that the D.C. Court of Appeals issues its order in that case. And they should indeed and predictably will find that Judge Chutkan was proper in determining that there's no presidential immunity, that the case against Donald Trump on those 4 counts in the indictment against him in the federal district court can and should proceed. She is waiting for that. The District of Columbia Circuit Court needs to resolve this matter very soon because, of course, what is it doing? It's delaying the trial. And indeed, yesterday evening for the first time, we've got a clear statement from Tanya Chutkan about the impact of this appeal and the process by which this is going forward. Now, once again, does Donald Trump have a right to appeal this? Absolutely. That's what we anticipate in our courts. It is taking a long time. And now, out of some frustration, Tanya Chutkan says, I'm taking all this off my calendar. We will see if and when those immunity claims are resolved. And of course, what could happen next? Well, after the D.C. Court of Appeals, hopefully, presumably very soon, decides to resolve that matter, Donald Trump could seek an appellate review, seek a writ of certiorari in front of the Supreme Court, and that would only further delay this matter as well. As we've talked before, the Supreme Court should decline to review this case and should, in fact, send it then back down to Judge Chutkan so that she can put this back on her trial calendar and get this underway. When we come back right after this break, talk about the consequences of her decision just yesterday to drop kick her March 4th trial date and presumably... Our final segment of our first hour here in our Saturday morning broadcast, talking about things pending before the Supreme Court and also pending before the D.C. Court of Appeals. This issue identified by Tanya Chutkan as without merit. The issue being whether a president is immune from criminal prosecution, finding that indeed that doctrine does not apply. The D.C. Court of Appeals still has under advisement, still taking its time, if you will, to resolve that matter. If indeed the circuit court, as it should, affirms the lower court decision, Donald Trump, again, a part of the due process that he claims is being taken from him, at least in this other matter, part of that due process, he has a right to seek additional review by the United States Supreme Court of that D.C. Circuit Court decision. Now, the Supreme Court should, in an exercise of good discretion, decide not to do that and leave this alone, leave the law of the case as the D.C. Circuit presumably will decide it, as Judge Chutkan has decided. But if the United States Supreme Court decides to take that case on, then it would offer that the scheduling of the trial in this matter is truly being delayed inordinately during this election year, during any time. Why? Because after the Supreme Court takes this case, it will once again, could even expedite the process, but still will solicit from the parties more briefs on this issue, some more written things submitted not only by Jack Smith, but also by Donald Trump. Again, a part of the process that he would be afforded in the course of this litigation before the Supreme Court. And then presumably would schedule on oral argument. And that too would take some time. And then after that, the Supreme Court resolve this matter, hopefully finally finding that indeed there's no presidential immunity. But all of that would presumably add weeks, if not months, to this process. Now that's already been suspended by Judge Chutkan as of yesterday, finding that the pendency of all of this prevents her from going ahead and keeping that March 4th trial date on the calendar. As an important footnote to all of this, significant that among the 4 criminal cases, as you may well recall, the very first one charged was by the Manhattan District Attorney. His name again, Alvin Bragg. This is the hush money case involving Stormy Daniels, also involving, as we know well, the former fixer, if you will, Michael Cohen, the former lawyer for Donald Trump and his organization. That case pending before a judge named Juan Merchan. And he's going to be having a hearing on February 15th in the New York Manhattan State Court. That's a criminal case alleging, once again, violations of state law by the DA. And the district attorney there has said, well, gee, if the federal case doesn't go in early March, we can put this trial before a jury in this Manhattan case courtroom as well in front of Judge Merchan. The trial right now is scheduled to begin on March 25th. And indeed, it has also been slowly but surely moving forward. Again, the due process appropriately afforded Donald Trump. And indeed, there's good reporting that the Manhattan DA's office is approaching witnesses to prepare them for the proceeding. And that, of course, includes Michael Cohen in this process. Entirely possible that the first among the four major criminal cases, the other two out there, of course, the Georgia case and the Mar-a-Lago documents case, that the very first case going to trial could indeed be the first one that was charged way back when, about a year or so ago, alleging improprieties, violations, criminal violations of New York law. That could go in front of Judge Merchan, who is, again, going to, in just a week or so, going to have a status conference to decide when indeed that case is going to be tried. Right now it's on his calendar for March 25th. That indeed could happen. All of this plainly interrelated. And once again, the reason why we spend time talking about it this morning is it refutes this notion that Donald Trump articulated, admittedly just in connection with the E. Jean Carroll matter, but that the judges are against him, the witnesses are against him, the evidence rules are against him, juries are against him, democratically appointed judges, judicial officers, all these people against him. It simply isn't true. The fact of the matter is that in all of these cases, he is being afforded the appropriate, arguably even more due process than other defendants in the civil and certainly a criminal arena might otherwise be afforded. As always, we appreciate your listening, but also appreciate your phone calls. And delighted this morning to have a couple of callers, some listeners calling in. Let's begin with Nick from Madison. Nick, your comment or question this morning on our Saturday morning broadcast.
Hey, yeah, thank you for having me. Here's the thing. It's like, I'm a conservative, but I am not a Trump supporter, okay? Because everything you're saying about how he's basically being empirical,
right,
being an emperor.
As Judge Chutkin said, we have presidents, not kings. And again, to your good point, Nick, the notion that somehow he is being unfairly treated simply isn't true. But again, go ahead. Appreciate your comments here.
Absolutely. But here's the thing. I mean, it's not like this is a new thing. President Obama, who I didn't agree with, but I think he's a good guy. He said, direct quote, "I'm not going to wait for Congress. I have a pen and a phone." So this isn't new, is what I'm saying.
Sure. And again, I think you're right, Nick, that every single president has been frustrated by Congress, right? Democrats, Republicans, whether it's Bill Clinton, Jimmy Carter, candidly, anyone, Barack Obama, George Bush, everyone, Ronald Reagan, they've all been upset by the failure of Congress to act. And the thing that you're specifically talking about, I suspect, is in the area of immigration, where Barack Obama said he's waiting for immigration legislation to come forward and said, you know what, I've got this capacity to issue executive orders. And that's what he did. And that had to do with DACA and other related things. We know that remains in the courts. Why? Because people come forward as a part of our system and challenge that executive order. Again, that's what we embrace. That's what we should do here in America. But the reality is that,
and that's what I think, though, is that the failure of Congress to act, that's a feature. It's not a bug. Congress shouldn't just do things. Okay, it should debate. It should get through things, and there is compromise involved.
Sure, absolutely. And,
And
I would say, you know what?
Presidents don't like that.
Well, I think that I agree with you to the extent that Congress has this obligation to act. I would say that they should be doing things. And when we come back after this first break, we'll chat more about that particular obligation, I would say, to legislate in the areas of immigration and environment and even commerce and all the other things that are going on right now when presidents become frustrated by the failure of the Congress to do things after debate, and specifically with immigration has been pending for a very long time. That's when presidents begin to act on their own, maybe lawfully, maybe not. That's what the courts are also about. Nick, appreciate very much your comment this morning, and we will continue to entertain those kinds of good civics observations and questions about our history as we go.
UK.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Good morning.
Sampling the
And
news desserts of the week, here is your host, Jim Santel.
Good morning and welcome once again to our Saturday morning broadcast. This is the second hour of our discussion this morning, talking a lot about civics and about the due process it has afforded litigants, both in the civil and criminal arena, including the comments made by the former President Donald Trump about his own experience in the federal district court recently in a civil matter, talking a lot about the process by which our courts work, the role of judges in serving not only to administer cases, but making decisions under the evidence rules, making decisions about all sorts of things that are brought before the courts, ultimately brought before a jury to decide on the ultimate issues of fact that litigants are seeking. Right before the break, we're talking to Nick about his observation. He said that none of this is new. There is a lot of this that has always been the subject of discussion and debate. Nick was making the point, of course, that presidents, as I interpret it, have often been frustrated by the Congress and so have done things in their official executive positions that have been the subject of litigation in front of the courts, and that too in the trial courts and the federal district courts, the circuit courts, the appellate courts across the land can always be the subject of litigation. In the particular instance that we have right now involving Donald Trump, none of these involve his express official activities and behaviors, and that, in fact, underlies the reason for much of this, if not all of this litigation. Courts finding that indeed when you engage in the kind of conduct in which Donald Trump engaged when it comes to not only defamation, but also when it comes to January 6th, things related to an attempt to overthrow the results of the 2020 election. Those are things not done during the course of duties and responsibilities as a president, and therefore can indeed be the subject of individual personal liability, criminal liability in our federal district and also our state courts out there. Nick, appreciate the comment. Let's also take some more callers calling in this morning about the subject matter on our agenda. Let's hear from Dick. Dick calling in from Madison. Dick, glad to have you with me this morning. And Dick, we'll get to you in just a moment or so. We're going to continue our discussion here. We'll see if Dick is still on the line there. Dick from Madison, are you with us this morning?
Yep. I'm here.
All right, great, Dick. We've got you. Thanks so much for calling in.
Great. What he would call due process, I call too long a leash, and here's why. After the first time last fall with the same person, Eugene Carroll, I read something that she had wrote that she's done well for herself in her own right financially. She doesn't really need the money per se. And basically what she was seeking is for him to cease and desist doing this stuff. And he never did, and he didn't continually. And now he does it through, in a roundabout way, he's still going after her when he goes after the jury, goes after the judge, on and on and on. In my opinion, he should have been thrown in jail immediately the minute he started running his mouth. He's getting by with far more than any average person would get, in my mind. And I just don't understand why they didn't you know, and then this excuse, oh, what could happen around the country? Well, what's happening anyway? And we're going to have to deal with this guy at some point. If he, in fact, is the nominee for president again, he's already said he won't accept losing.
Right. Lots of things, right, coming out of this. Lots of statements made by him that, again, are not only contrary to our fundamental notions of how things work, but to your very good point, the remedies that come out of this. Coming out of the E. Jean Carroll case, as you know well, Dick, this huge component of punitive damages. Now, you recognize, as we all do, that in the civil cases, you can't throw somebody in jail. You can get money. You can get injunctive relief. The judges can order things to happen or not happen. Only in criminal cases can someone be incarcerated. The singular significant exception to that, which we may see at some point down the road, came very close in a recent trial, is if someone is in contempt of court, even if it's in a civil case, under those circumstances, under appropriate process, a judge can indeed jail someone to respond to their contempt, even in a civil case. But that's not for the underlying charge in the civil case. But your larger point, Dick, is the important one. Why do we do all this? Why did E. Jean Carroll, as you just indicated, pursue this case? The particular dollar amount is perhaps, while it's colossal, is less significant than the message that it sends, which is no one should be permitted to get away with this in America, including especially somebody who has the bully pulpit of the presidency. He made these statements while he was in the Oval Office, denying he even knew her, denying the underlying events, all that kind of thing. And to your good point, Dick, the litigation process, the process of administration of rule of law, whether it is civil or criminal, needs to address that. And that's what this is all about. We talked again about the criminal case pending in front of Judge Shutkin. Likewise, it is meant to respond to the specific conduct, but it's also, to Dick, your very good important point, it's also meant to send a message, whether it's in 2024, 2025, that people who engage in this kind of thing and attempt to undermine the results of a legitimate election, that may well be the subject of charges against the next group of people. And that, too, is deterrence, not only, again, as to the individual defendant, but to other people out there, sending that message of deterrence. You can't do this. And that's the other reason why criminal prosecution, much like civil litigation, is important in our courts. And so appreciate that comment as well, Dick. And we also have calling in this morning, Mark. Mark, appreciate your being a part of our discussion this morning on our broadcast.
Yeah, it's certainly that as I've said before, that in Federalist 69, that Hamilton actually says the president would be subject to punishment and disgrace. I mean, he uses the word amenable, but that just means subject to in the context he was using. And this is all part of the whole Donald Trump shtick that we've been seeing for all these years. Any other person can maintaining decorum in the court like Donald Trump has had. He's had no decorum. He's just complete contempt of court. He would be in jail. And we have to remember that this is all part of restoring him to office so he can pardon himself. And this is all linked into the whole conspiracy against our country that started actually before the last election. Is that they planned on Donald Trump. He planned on never leaving office, and he conspired against the Constitution, the people of the United States, with the fake electors thing. Because he had them, the one thing he said when he was given his speech on the ellipse said, "Go in peace." But before that, he had fired these people up. So that was just kind of an aside. It was just an aside. It was more of an aside, when Henry II made that flip comment, "Well, somebody rid me of this querulous monk," when he more or less ordered for Becket to be killed. Donald Trump had issued his orders, what he wanted people to do. And in my opinion, this is simply my opinion, but I think the whole fake electors thing was part of the conspiracy to overthrow the government of the United States. And I do not believe for a moment that those people that were engaged in being a fake electors misunderstood what they were doing.
Right.
I mean, and the people who knew about what was going to happen, including Brian Schimming, the current Wisconsin Republican Party chair, knew that this stuff was going on, and their absolute duty was to report this to law enforcement, to the people of the United States. Because
and we know, Mark, based upon exactly what you're saying, that this was a part of an overall scheme. We know about the attempt by the people surrounding Donald Trump putting together this memorandum, first called the Wisconsin Memorandum, and then later on this larger memorandum. The fake electors, a part of this overall scheme, including an attempt to coerce, if not actually compel somehow the vice president to throw out votes in the well of the Congress. All of it, reaching out to Georgia, reaching out to other places around the country, trying to get the electors off the proper electors off the scales and off the official tolls and substituting these fake electors. All of that a part of this overall scheme designed in many ways by this fellow named Cheeseman, who is one of the unindicted co-conspirators in this case involving Donald Trump, pending right now in front of Judge Chutkan in the D.C. District Court. And so that brings us to what's going on then this coming week, directly related to all of this combination of the campaign going on in 2024, interspersed with all this litigation, including criminal and civil cases. What's happening next week in the United States Supreme Court, Thursday, February 8th. Mark your calendars. Thursday, February 8th, the Supreme Court is going to be entertaining oral argument on this case called Trump versus Anderson. And it is not a criminal case. It is different from the district court case, the criminal case that Mark and others and I were just chatting about, seeking to find Donald Trump criminally liable, criminally responsible for the events of January 6th. This is the one. This is the case in which there is a challenge to the decision by the Colorado Supreme Court to keep Donald Trump off the ballot for what? And here's how the connection comes in: for engaging in insurrection on January 6th and arguably right before that. The question, of course, in this case, Trump versus Anderson, is how you interpret Section 3 of the 14th Amendment, providing that no person will hold any office under the United States or under any state who, having previously taken an oath as an officer of the United States to support the Constitution, if you subsequently engage in insurrection or rebellion against the same. That's the constitutional provision that's been the subject of so much attention and litigation focus recently. In December, the Colorado Supreme Court, in this 4-3 decision, we've talked a lot about it, determined that Donald Trump was in fact ineligible, not appropriately to have his name listed on the presidential primary ballot in that state by virtue of an application of Section 3 of the 14th Amendment. So all of this coming up before the United States Supreme Court next week. It's going to be a big week in the rule of law in the United States of America. So there's several legal issues. Arguably, you're going to be hearing about them in front of the Supreme Court when the folks, the individuals from Colorado who have been petitioning to keep him off the ballot, are in the same room with the attorneys for Donald Trump, seeking to have his name put back on the ballot in Colorado. What are those issues the Supreme Court will probably take up? First, there's an issue about political questions. Should the court at all adjudicate cases under the 14th Amendment or deem them political matters? The court has in the past, in many circumstances, has held that cases are what's called non-justiciable political questions when there is this perceived need to defer to the choices of other elected officials. So this is what's called the political question doctrine, and basically says that federal courts should not adjudicate a matter. It doesn't bar state courts from doing the same thing. So, for example, a court held that challenges to partisan gerrymandering are non-judiciable political questions. Supreme Court found that recently and found instead that that's the kind of thing that state courts can address. When we come back, we're going to talk more about what's before the Supreme Court this coming week. Stay with us for that important discussion. Saturday morning broadcast, talking now about this big week coming up in the rule of law in America, including this major oral argument before the United States Supreme Court next week in this case called Trump versus Anderson. This is the one in which the parties are arguing about whether or not Donald Trump's name can be on the Republican primary ballot in the state of Colorado. Colorado Supreme Court, again, previously saying that not only did Donald Trump engage in insurrection, but the application of Section 3 of the 14th Amendment is proper here, keeping him off the ballot. What kinds of things will the Supreme Court presumably be talking with the parties about when this coming Thursday they decide to entertain this case and talk with the parties about the merits and demerits of their positions? talked right before the break about this political question doctrine, this notion that federal courts should not generally adjudicate a matter that is political in nature. And so, for example, partisan gerrymandering, court has said, is a non-justiciable political question. State courts can do it, but not federal courts. And, of course, that would be a huge, huge disposition if indeed the court says this is a political question, we're not going to decide it at all. Second, another question they could decide is whether or not Section 3 of the 14th Amendment, it requires some congressional legislation in order to be enforced. Who actually is responsible for enforcing this language under Section 3 of the 14th Amendment? 1869, there's a Chief Justice, Salmon Chase, who said that Section 3 was not self-executing. He wrote, legislation by Congress is necessary to give effect to the prohibition. Now, plainly, a lot of people agree with that. A lot of people disagree with that. But one of the issues that the Supreme Court may decide, or at least may wrestle with this coming week, ultimately decide, probably sooner rather than later, is whether or not Section 3 is self-executing, whether or not you need congressional legislation. And in fact, in 1883, the Supreme Court said the 14th Amendment is undoubtedly self-executing without any ancillary legislation, so far as its terms are applicable to any existing state of circumstances. That's what they said back in 1883. There's some precedent out there for this notion of a self-executing provision, not requiring legislation, not requiring a criminal conviction. But we'll see whether or not the Supreme Court pursues that particular precedent out there from way back in 1883. Third, here's another question coming up in Colorado that they could also entertain this coming week. Does Section 3 apply to the president? Now, this one strikes me and many other people as a fairly clear one in terms of its answer. You recall that the lower court judge in Colorado, she found that although there was an insurrection and that Donald Trump engaged in that insurrection, she looked at the language of Section 3 and said, you know what? This language of officer does not include the presidency. Awful lot of people, I would conclude myself among that group, scratch their head about that. And the question is whether or not the specific reference to office includes the presidency of the United States of America. Presumably, there may be questions about that particular applicability. And fourth, the big one. Did Donald Trump engage in insurrection or rebellion using the language from that particular provision of the Constitution? Many, many aspects to that question. Does there need, as I said before, to be a criminal conviction as a predicate to finding insurrection or rebellion? Nothing in the language of the 14th Amendment says that, but maybe the Supreme Court imposes that requirement, even as it wrestles also with a legislative obligation to find, indeed, that it should be enforced. What, if anything, is the relevance of the House of Representatives having impeached Donald Trump on this, but the Senate not having convicted him? There again, I would offer shouldn't be a major question, but maybe raised during the course of the oral argument. Does it matter, as one of our callers said just a few moments ago, does it matter that Donald Trump's speech on the ellipsis there that morning, arguably, from his perspective, falls under the protection of the First Amendment? And of course, we know that there's no amendment that is not without conditions. First Amendment does give us an awful lot of opportunities, including right here on this radio program, you publicly in many, many different settings, not only to comment about things, but also to be critical of people and even government. That is a part of our First Amendment. The question is, in the case of E. Jean Carroll, for example, does the First Amendment protect defamation? The answer is no, it doesn't. If, in fact, you've said things are false, they're provably false, and they've had some damaging effect upon an individual, that's a limit on the First Amendment. Likewise, the First Amendment does not encompass the capacity to incite insurrection, to encourage riots, to encourage violence. There is a limit, and the Supreme Court has said that in the past. There are limits on what the Fourth Amendment protection provides to all of us. I cannot overtly encourage violence and get away by saying, well, that's my First Amendment right. How is that determination to be applied here in this particular case? Certainly would be unprecedented for the Supreme Court to disqualify a leading candidate for the presidency of the United States of America. But these kinds of things, as we all know, we're going to use the word once again, unprecedented, right? Donald Trump's actions are unprecedented in the history of our nation. There is a lot before the Supreme Court. And the point of this exposition this morning in connection with this oral argument coming up is just this. My own prediction is that the Supreme Court will, in one way or another, not support the Colorado decision, put him back on the ballot. But it's got a number of different off-ramps, if you will, a number of different ways of doing that. Procedural things could find that indeed he was not afforded the proper due process in the Colorado Supreme Court. That's going to be a heavy lift just because there was a trial here. The trial court judge afforded witnesses the opportunity to come in, all sorts of testimony. That's going to be a difficult thing to establish, but maybe there's an argument there. But all of these other jurisdictional issues, who decides? What does insurrection mean? What does the 14th Amendment mean when it comes to political questions? Is that applicable here? All these kinds of things are things that the Supreme Court could and probably in one way or another will seize upon in overturning the Colorado decision, placing him effectively back on the ballot. The reason why this case is so important, of course, is there are other states looking at it to determine what the Supreme Court says in connection with their own invocations in their own states about Section 3 of the 14th Amendment. We know that Maine right now, Maine is awaiting the decision in this case, presumably coming up sometime soon, Trump versus Anderson, awaiting that decision to determine whether or not the Secretary of State's decision there to keep him off the ballot in Maine should be supported. Lots of things depend on this prediction. We will see. We will see. We can never tell exactly what the Supreme Court is going to do. We'll see, especially read some tea leaves from this coming Thursday to determine whether or not the Supreme Court is seriously entertaining the notion of supporting the Colorado Supreme Court or going in the opposite direction. Again, this is one where it's difficult to predict with certainty how they get to it. My own sense could be the subject of reasonable people disagreeing with me on this, which we always encourage. It may well be that they would disqualify him from that, but then once again would be a precedent-setting thing for the Supreme Court to do, likely that they will go in the direction, one of these other directions, and find that the Colorado Supreme Court was in some way, one way or another, erred in keeping him off that ballot. But it's got to decide it fairly quickly because, of course, all this coming up, Super Tuesday, all of this, the other theme of 2024, timing as we go forward. Coming up as well in the month of February, again, a case involving, actually two cases involving social media. And when we come back after this break, we're going to talk about a case called Booty versus NetChoice and NetChoice versus Paxton that have to do with the internet and social media, the implications, the relationships between government and the connections between things that are posted and monitored and taken down by platform providers out there. Stay with us following this break for that all-important discussion about other cases before the Supreme Court this coming week and in the weeks ahead.
On the Shaw, 540 AM and 101.1 FM, WAUK. Weekday afternoons from 4 until 6. On the Shaw, 540 AM and 101.1 FM, WAUK.
Back here for our continuing discussion at this point in our Saturday morning broadcast about things pending before the United States Supreme Court. A big week next week as the Supreme Court entertains oral argument in this case, determining whether or not Donald Trump's name will continue to be on the Colorado ballot. Lots and lots of options for the Supreme Court, substantive, procedural, to decide that case, presumably long before May and June of this year, presumably sometime soon, in anticipation of balloting in Colorado and in other places around the United States of America. February is a big month in the Supreme Court. There are, in fact, 59 cases to this time in which the Supreme Court has granted certiorari on its docket. We've talked about many of those. It may well be that if this matter involving presidential immunity comes up from the D.C. Circuit Court, that could be number 60. And it's usually somewhere right around 60, maybe 70 cases or so. The Supreme Court pretty much ends its taking new cases at or around those numbers. We'll see how those numbers play out in the weeks just ahead. But in the month of February alone, 11 different cases, 11 cases, including Trump versus Anderson, on the docket for oral argument. And what are some of those other cases? Well, on February 28th, near the end of this month, a case called Garland versus Cargill, Cargill. This is his major case involving the legitimacy of bump stocks. We've talked about this in the past, whether or not the ATF has the ability, the power, the authority to provide and enforce a rule banning bump stocks. Bump stocks, once again, these mechanisms that basically convert rifles into machine guns. And based upon that capacity, ATF, the executive branch, maintaining that bump stocks should be subject to a rule, subject to prohibition under the administration of those rules, because you're converting them from a rifle to a machine gun, which by its very nature is illegal in America. That case coming up for oral argument on the 28th of this month, again, joining some other cases in the firearms area that we have also talked about in the past. Next, coming up on the 26th, also this month, the 26th, a couple of cases involving the internet and social media. Let's talk about those right now. Florida and Texas, two state legislatures, Florida and Texas, adopted laws that prohibit social media platforms from engaging what they call content moderation. You probably know what that's all about, requiring them to provide an individual explanation of every decision to remove material that's made by social media platform providers. In other words, if they're going to take something off their social media platform, they got to explain individually as to each posting why it is you're taking that off. Plainly the product of some dissatisfaction with social media providers removing incendiary, inappropriate, inaccurate statements on their social platforms. Florida statute, it's SB 7072, applies to any platforms with an annual gross revenue of more than $100 million or more than $100 million in 100 million on monthly users. And here's the significant part of this legislation. It prohibits the willful deplatforming. Deplatforming is the verb that's used, a candidate for office. You can't remove somebody from the platform because they're a candidate. You can't do that willfully. And in addition to that, a platform is prohibited from censoring, deplatforming, or shadow banning a journalistic enterprise based on the content of its publication or broadcast. That's the language of that law coming out of Florida, basically saying you can't censor, you can't ban journalistic enterprises based merely on content. And if you do, you've got to provide an individual explanation about that particular decision to remove that content. It poses a huge burden upon, obviously, those social media providers that are trying in many ways, perhaps unsuccessfully, but trying nonetheless to try to monitor the content that's out there. The Texas laws, HB 20, is very similar. It just basically flatly prohibits social media platforms from censoring a user's expression or a user's ability to receive the expression of another person on the basis of viewpoint or geographical location. Very, very broad. The prohibition applies even if the viewpoint is not expressed on the social media platform, and by that they mean that platforms cannot remove users or their posts on the basis of things that those people or those entities may have said in other settings. It's huge. Again, prohibiting those social media platforms from censoring expression on those platforms. Now, the 11th Circuit, the U.S. Court of Appeals in the 11th Circuit, already declared the Florida law, this first law that I described, as unconstitutional. And it stresses social media platforms, like all other private media companies, have the First Amendment right to choose what to publish. All important. By contrast, opposing, if you will, the 11th Circuit, the 5th Circuit Court of Appeals has upheld that very broad Texas law, and in its decision emphasized that internet and social media companies should be regarded, as they said, as common carriers, and therefore they're subject to regulation to prevent them from excluding speech. Very different opinions coming out of the 5th and the 11th Circuit. Thus, the Supreme Court resolving not only this dispute between the circuits, but also determining what it is that social media providers can and cannot do by virtue of legislation, state legislation, basically telling them that you cannot remove content that is found to be violative of basic standards. So what are some of the information out there about the history of this? They do already do an enormous amount of content moderation, as I said before. Maybe not enough, maybe too much, depending upon your particular perspective. But from October to December of 2021, for example, Facebook took action against terrorism content 7.7 million times. It took action to remove bullying and harassment 8.2 million times. And it took some action to remove child sexual exploitation 19.8 million times during that same period, October to December of 2021. In the last quarter of 2020, Facebook took action on an average of 1.1 million pieces of content every single day. So these cases coming before the Supreme Court, again, are going to be heard, oral argument, on February 26th. The name of the case is, once again, important to note this for your calendars and understand what the Supreme Court is going to be deciding on these very important issues related to social media. Moody versus NetChoice, and NetChoice versus Paxton. And yes, Paxton is the name of the Attorney General in the state of Texas. Those coming up for decision by the United States Supreme Court. No great timing issue on there, but likely going to be issuing opinion on those two, presumably consistent in both cases, sometime in May, sometime in June. And we will certainly be monitoring that, as we will monitor later this month on February 26th, these oral arguments before the United States Supreme Court. 11 cases altogether before the Supreme Court this month alone. Right now, the Supreme Court's overall docket, just under 60 cases to be decided in this 2023-2024 term. We've got some additional callers on the line. Thrilled to have a conversation this morning with all of you. First from Madison. Joe, your comment or question on our Saturday morning broadcast. And Joe, do we have you on the line? I think you're there. We'll continue to wait as we pull you up. Joe, there you are. Very good.
Yes. Great. Great show, Jim. And I wanted to ask a question in reference to the 14th Amendment.
Yes.
And you were talking about the interesting situation we have here. We have this unprecedented court case when an ex-president is basically saying, look at this Section 3 of the 14th Amendment doesn't apply. And offers a slew of reasons. And one of the things I was interested in was your reaction. You had said, we don't really have a precedent because we've never had an ex-president do something like this. But we do have a precedent from the past in terms of Confederate leaders, generals,
Yes.
Those politicians were not allowed to hold office. And as I understand it, they did not have jury trials about this. They did not have indictments. It was just accepted that if you were part of that establishment, it was understood that you had engaged in insurrection. And then in terms of present day, there is also this, back last year, there was a man who had been at January 6th and had been deemed
Yes.
by a judge to have engaged. His name is, last name is, it's in Otero, New Mexico. His first name is Cowboys for Trump, and his first name is Couy, Couy Griffin. And he court commissioner and was bumped from his job
Absolutely.
because he had engaged in insurrection. So we do have precedents, right? So in terms of what the Supreme Court wants to do, it could look to the past for the Confederates, and it could also look to present day, to this particular gentleman. So I guess I'm just curious if you to expand a little bit more on, couldn't they use that precedent to say, hey, you're not any different than any other citizen, you engage in insurrection, and this precludes you from gaining office by the 14th Amendment. Can you chat a little bit more about that, Jim? I appreciate it.
Be delighted to, Joe. Excellent points, as always. Let's talk about, first, this New Mexico case. Yes, we've talked about that case previously on this very broadcast, and it is the precedent, as you said, Joe, for an individual, again, previously been convicted in the federal district court in the District of Columbia for engaging in the insurrection. So you've got a criminal conviction there, okay? Again, to the extent that this issue relates to whether or not criminal convictions can form the predicate for keeping somebody off the ballot, there is that precedent. It doesn't have to do, of course, with a candidate for the presidency, and of course that state elected officer there, not in Colorado, but in New Mexico. But there is that, and absolutely that precedent, fairly recent, invoked by a state court judge there that says, the 14th Amendment compels me, based upon your criminal conviction for an insurrection, to keep you off the ballot. And there the question is it self-executing? Doesn't need to be, because you've got the conviction already. Very important thing to note. And beyond that, will this issue about the post-Civil War removal from government with respect to those people who engage in the Civil War, having previously taken the oath of office, serving in the government, will that be argued? Absolutely. That kind of thing, again, especially when it comes to the decision about whether or not the 14th Amendment is self-executing, or whether you need a conviction, whether you need legislation, there will be argument. There will be argument this coming week that indeed you don't need any of that, Joe, as you most accurately have said. All you need to do is look to history. The precedent-setting aspect of this, of course, is we've never had someone run for president seeking to return to the White House when indeed they're on a ballot and a state court has said, we're going to toss you off that ballot because of your involvement. That's the aspect of this, is precedential, but an awful lot of reference points, Joe, as you accurately note, that can in fact be invoked and will indeed be argued by the parties on both sides of this under any of these various rubrics, these jurisdictional aspects we talked about, deciding whether or not there's insurrection, deciding whether this is a political question, who executes this, all of that. There will be an argument that the Supreme Court should look to the past and should look to the recent past in saying that indeed this is how the law should be applied. Great points, Joe. Appreciate your comment. Also have calling in from right here in Waukesha is Kristen. Kristen, glad to have you with me on the program this morning. Welcome.
Hey, Jim. Regarding the social media case out of Texas.
Yes.
Am I understanding this correctly, that if someone is harassing you in person, somehow,
right,
they can also harass you on social media?
Absolutely, it happens, right?
And you can't block them, and the social media company can't remove them?
Right. So
how does that run up against like stalking and harassment laws, if they even have those?
Right. Isn't that a great point, Kristen? Right. Again, look at
that's crazy.
That is both I'll say that's the legal word, Kristen, and that's the commonplace word as well, right? Look at once again at this Texas law passed by the legislature, endorsed by the Attorney General, signed by Governor Abbott, flatly prohibits platforms from censoring a user's expression or a user's ability to receive the expression for another purpose on the basis of viewpoint or location. And because of that, the platform provider prohibited from taking that person offline. Raises all kinds of questions, as you indicated, about stalking, criminal exposure, all those kinds. And this is our final segment on this Saturday morning broadcast. Thank you once again, all the terrific callers this morning, and also for continuing to listen to the very end here on our Saturday morning broadcast, talking about these major cases before the Supreme Court, social media cases, as Kristen was just commenting about, the implications of those kinds of practical arguments, how these laws run up against the basic understandings about stalking and criminal prosecution, harassment, even defamation, if you will. And Joe also raising some very good issues also to be argued before the Supreme Court when it comes to this case involving Trump versus Anderson, and giving the Supreme Court some sense of the implications of keeping and not keeping Donald Trump on the ballot, looking back to history, both historical references, but also contemporary things, the implications of that for today in our political environment. Recently, about 2 weeks ago, the Supreme Court issued another very important opinion having to do with the enforcement of immigration law. And we've talked at great length before about the fight, if you will, between Greg Abbott and, yes, indeed, the Attorney General in Texas, the governor and the Attorney General there when it comes to the enforcement of immigration laws. A huge amount of reporting on that, of course, a huge amount of focus on that right now in front of our United States Congress. This has to do with who is responsible for enforcing the law on any border, generally, when it comes to immigration. We know that the Supreme Court is already has before it a major issue having to do with this decision by the executive branch to remove some of the concertina wire that has been placed along the southwest border by the governor and by other officials there. Well, about 2 weeks ago, the Supreme Court sided with the Biden administration and allowed federal officials actually to remove parts of that concertina wire along the Mexican border that the Texas officials, the governor, the attorney general had erected. Why did they do that? To keep migrants from crossing into the state. A major win, if you will, not only for the administration, but I would argue even more than a litigation victory, it's an affirmation of the Constitution. Why? Because George Mason, James Madison, all the other founding fathers expressly said that immigration issues, when it comes to enforcement of immigration laws, those things inside the purview of the federal government. And so, by a 5-4 vote, a victory for the administration in this dispute between the White House and Governor Abbott. And of course, all of this related to this campaign that's being pursued by Governor Abbott and others in Texas to address this issue of migrants along the southwest border. No disagreement among Democrats, Republicans, independents, across the board. I suspect all of us, reasonable people out there, can agree that something has to be done about immigration. We talked about this a bit in our earlier hour when we commented about the obligation of the legislature to do something, to act, to engage in behavior, and to pass legislation to address this continuing festering problem that has to do with immigration. The system is undeniably broken, both in practical implication and also in its broad brush strokes. Now, we know that as a result of that, the governor has, again, placed this concertina wire along the barrier. And although the Supreme Court, in lifting an appeals court ruling that had prohibited the administration from removing that wire, the Supreme Court gave no reasons for its decision to overturn that decision and therefore permit the executive branch, the folks along the southwest border, our law enforcement authorities there, from going ahead and removing that concertina wire. What we do know from the Supreme Court case of a couple of weeks ago is that Chief Justice John Roberts and Justice Amy Coney Barrett joined the other three liberal members of the court, so-called, to form this majority. And so you've got two members of the Supreme Court joining, also Ketanji Brown Jackson and Elena Kagan and Sonia Sotomayor, coming up with this 5-4 majority, saying President Biden, the folks along the southwest border, the Border Patrol agents responsible for this, you may remove that wire. Why? Presumably why is because this is in violation of the fundamental establishment in the Constitution of responsibility for immigration in the federal government and not the state government. Lots of commentary in the wake of that. Plainly, the war continues there, and the disagreement about the concertina wire and many other things goes on. The Attorney General, the governor himself, Governor Abbott, has vowed not to follow the rules and directives of the Supreme Court. And there is dispute right now. They're attempting, if you will, to prevent Border Patrol agents from removing that very concertina wire the Supreme Court said can be removed in the exercise of discretion, law enforcement discretion, along the southwest border. This particular issue, plainly not over, and again raises an issue about the rule of law as a governor looks at the Supreme Court and says, we're not going to follow what you are saying, or at least not in practice, not yet. And so concertina wire becomes a major issue when it comes to the enforcement of immigration policies and practices in America, underscoring again the need for our legislature to work. The need for our legislature, as it is wrestling with right now, to pass some comprehensive law enforcement or directives and principles that will guide not only administrative law judges adjudicating all the immigration cases, that will address cases of asylum, a huge issue which we've talked about at great length. All those kinds of things have got to be addressed by our legislature. One of the other themes, of course, we talk a lot about in this show is this notion that many of these cases, many of these issues coming before the Supreme Court, why? Because the legislature is not acting. The executive branch, as one of our callers in the first hour indicated, sometimes very frustrated by the fact that it also not able to act when courts prohibit it from acting. Well, the legislature needs to act in these areas more and more in all these areas that we've described this morning. These kinds of things come to the courts, the district courts, the circuit courts, and yes, indeed, the Supreme Court, when our legislators, the people we send to Washington, D.C., have not wrestled in a way that brings to some conclusion, even if not everyone agrees with it. That will never happen in America, at least not today. But even if we don't have complete agreement on how, for example, immigration law should be structured, if we don't have agreement on environmental law, other things in the area of commerce and the economy, all of those kinds of things, they need to be addressed by the people through their legislature in Washington, D.C. We will continue to discuss all of these things and more in our future broadcasts here on the Saturday Morning Show. Appreciate, as always, your time, your attention. Value your contributions. Continue to call in, continue to be a part of our conversation as we address things related to law and government and the administration of justice in this country, our United States of America. Have a good week, everybody.